All right, I think we've got 12 o'clock right on the dot. So welcome everybody this afternoon to new fiduciary process requirements for ESOP trustees, document. Glad to have everybody on the call, and hopefully everyone will be able to take a tidbit of information out of this to apply to your own roles, whatever that might be in your companies. I believe we have a variety of folks on the line today, ranging from individuals in companies to some of our professional ESOP trustees, both institutional and individuals. So welcome one and all. So a topic that has gotten a lot of activity and awareness recently is with regards to the fiduciary process requirements. So Saker, Fisher, Edwards, and Greenapple and SES Advisors is pleased to have the opportunity to give everybody some background, sharing some of our thoughts on how this affects our ESOP community, and hopefully some pointers for everybody as you hear this bantered about in the ESOP arena. So my name is Tabitha Croscut. I'm the managing shareholder of Saker, Fisher, Edwards, and Greenapple. And just going to take you through here, if I can figure out how to proceed my slide. So the agenda, just to give you some overarching ideas here, we're going to talk about the Perez Great Bank Trust Company case. That is how the fiduciary process requirements were derived out of this particular case, otherwise known more fondly as the Sierra Aluminum Company case. We're going to talk about who the fiduciary process actually applies to, what does it actually apply to, and how does it apply, because I think there are some misunderstanding amongst those who might not just be very familiar with that case and what the settlement agreement entails. So we're going to give it some more clarity for folks. So let's talk just briefly about the case for which the fiduciary process requirements came out of. So the Department of Labor filed an action, a complaint against the Great Bank Trust Company back in 2011, actually. The lawsuit has various allegations, all deriving from a second stage ESOP transaction, that is a second purchase of stock from selling shareholders by the ESOP, and that transaction happened in the 2006 time frame. The initial complaint from the Department of Labor alleged the typical allegation, overpayment in excess of fair market value for the company's stock. It also sought, another important detail, sought to block Great Bank from obtaining any indemnification monies from the company. And so actually the initial decision from the court was focused on that indemnification piece, and I believe Great Bank won on that. The second stage of that court, I'm getting a pop-up message, so I'd be hearing something. If you're not hearing anything, I'm not sure you're going to hear this message, but there is a phone number to call into. So the initial complaint then, after dealing with the indemnification issues, then set forth to deal with whether the trustee actually overpaid for that stock. And that is when discussions commenced between the Department of Labor and Great Bank. As I understand it, Great Bank actually initiated those discussions and began meeting in December of 2012. Those discussions took various formats, and in June 2nd, just recently of 2014, both parties agreed upon a settlement. And that is where we get the fiduciary process requirements from, and I use the word requirements loosely. The settlement agreement contains a number of items, of course, starting with a monetary penalty of the $4.7 million that Great Bank was asked to pay over to the ESOP itself for the benefit of the participants. And then we have $477,000 plus to the U.S. Department of Labor for the DOL for the 502 payment that is just a statutory penalty payment. Those payments are spread out over a 3-year period, but of course, no one wants to pay $5+ million. So, in addition to the penalty, the monetary penalties, there was also some closure, and this is certainly what Great Bank was hoping to accomplish, and that is to get a release from the Department of Labor from some other cases, some other complaints that had arisen prior to the settlement taking place. And so the settlement agreement includes a release, settlement and discharge of all claims, demands, actions, causes of actions, liabilities, or fines, including that 502 ERISA penalty, and the investigation of whatsoever that the DOL may have against Great Bank relating to the ESOP stock transactions that closed prior to the effective date. So prior to the execution of that settlement agreement, any claims or demands, investigations that DOL may have commenced against Great Bank, they sort of get a pass for. So that's certainly what the communication between Great Bank and the Department of Labor was intended to do. Great Bank was hoping to do a couple of things, one of which was get rid of some of these lingering allegations and complaints and investigations. The second certainly was to get some better understanding of what the game rules were from the Department of Labor. So that's really the case, and that's the other portion of what the fiduciary process requirements were part of, a much larger case. So to whom and when do the fiduciary process requirements apply? And when we talk about the fiduciary process requirements, what we're talking about is, in addition to the monetary penalty and the waiver and some other details, of course, that would all be included in any settlement, there was an exhibit to the settlement agreement that included, or an attachment that included basically a list of process requirements specifically for Great Bank. So who does this apply to? This was a, let's see, 11-page document of steps of requirements that Great Bank has agreed to abide by. So the who, it absolutely applies to Great Bank Trust Company, who was involved in that complaint and certainly signed off on the settlement. Does it apply to anybody else? Legally, other trustees in the world are not required by law to comply with the details of that settlement agreement, of the fiduciary process requirements. It is not law, it's a settlement agreement, so it's not applicable specifically, I'd say per se, from a legal perspective. But we do have the quote from Philip Borsey that others in the industry would do well to take notice of the protections put in place by this agreement. So certainly, while there's not a requirement, it's not black letter law, it's not part of the regulations, it's not in the Internal Revenue Code, and it's not in ERISA. However, it is definitely something we want to pay attention to. So it doesn't specifically apply to anyone else, but certainly we want to take notice of it. When does it apply? Whenever Great Bank serves as trustee of an ESOP, specifically I want to point your attention to the statement, in connection with transactions in which the ESOP is purchasing or selling or contemplating purchasing or selling, or receives an offer to either purchase or sell non-publicly traded employer securities. So specifically, these steps are not going to take place every year for a trustee. These fiduciary process requirements were intended to apply at the point when an ESOP is purchasing or selling the company's stock in a non-publicly traded or privately held company. Whenever that occurs, Great Bank is now legally required to go through and follow the steps of the settlement agreement's fiduciary process requirements. So as I said, what they are not, what that process requirements are not, and again I use the word requirements loosely, is they are not law. It's not a regulation. It's not an advisory opinion from the DOL. It's not a field assistance bulletin. So they can't be used by the department in the court of law. So they can't say, oh, you per se violated your fiduciary duty by not completing numbers 1 and 3 on the fiduciary process requirement. That's not what it was. It might be intended that way, but that's not how it came out. So just because a trustee does not or cannot check the box on one of the fiduciary process steps, that does not mean that's a per se violation of the law. So what they are, what that process is, as provided in the settlement agreement, is an insight into what the DOL is expecting from each ESOP trustees when they're involved in the purchase or sale of company stock. I've heard through other arenas that the DOL has indicated they would have put a lot more effort into and more detail in the process requirements if they had been aware that others would focus on it so much. But I think it is a good guideline for trustees to at least take awareness of. So let's walk through now that you have some background as to what it is, who it applies to, noting that it's not a requirement by law, but what it contains, 11 pages. It's titled An Agreement Concerning Fiduciary Engagements and Process Requirements for Employer Stock Transactions. So what that includes, there are new requirements for ESOP trustees, and again, requirements is, I should put that in quotes. They're not requirements for all ESOP trustees. They're purely, I would say, guidelines. There are existing requirements that now require documentation. So at the beginning, the title of this webcast included document. I think it's something that everybody says. Historically, we've been saying that for a long time, document everything related to the ESOP transaction, and we do a really good job at that. And the ESOP trustees do a great job at that. But I think there are details of the transaction that we have all not paid particular attention to documenting, and now that we have the Department of Labor sort of looking and asking questions and folks not recalling perhaps some of the conversations or emails being deleted or destroyed per policies. We're now seeing the Department of Labor saying you really need to document. So not anything new, but now that we are focused on some additional aspects of a transaction of the purchase of company stock where you're going to document more readily. And then there are existing requirements that require nothing further for the ESOP trustees of the world. So these are details that the trustees have been documenting prior to the process requirements. So the first place that the settlement agreement, the process requirements start is with the selection of valuation advisor. I'm going to walk through actually each of the pieces now of that fiduciary process document. So get ready, it's going to be exciting. So we're going to look at the valuation firms really closely. And as many of you know, the Department of Labor has been taking particular notice of valuation firms, trying to bring them in and make them fiduciary so they can reach them in the court of law. And now what we're seeing is some of the requirement here is focused on making sure that the trustees are doing a complete and thorough job in their engagement of the valuation advisor, sort of trying to come at the valuation firms from who's engaging them instead of waiting for them to mess up, basically. So anyways, the process requirements are looking at what is going to be required when a trustee hires a qualified valuation advisor. So making sure that the valuation firm is qualified, that they are receiving all of the information that they need to receive, that the information is complete, it's current, it's accurate as they expect it to be, and all the necessary information. And then determining that reliance on that advisor is reasonable, noting that it's the trustee's legal obligation to set the stock value. And so making sure that they're not relying on the valuation advisor when, in fact, they know that reliance on that advisor is not prudent. So sort of something that should be known anyways, but now it's in black and white. So the process requirements indicate that the trustee should document the reason for making the selection, document those that were considered, discussing their qualification, listing their references, checking some prior background, whether they have criminal or civil cases in their history, and documenting why the conclusion of hiring a particular valuation advisor is prudent for that trustee. Of course, Great Bank Trust Company is a institutional trustee, and so they have a pre-approved list, as most, if not all, the institutional trustees do at this time. That is noting that each of them would go through and put the valuation firm through a review process. And during that process, they would be hopefully looking at all of the details that the DOL is looking for us to document. And then that pre-approved list would basically permit an institutional trustee to select from that list without having to go through that, that background check and discussing qualifications, all that every time they're engaged, since they typically utilize, the same list of people in all the transactions they do. So Department of Labor said, well, that's great that you have this pre-approved list, but we want to make sure that you're not working off of old information. So at the bottom of the slide here, you see if they're selecting from the pre-approved list, Great Bank has to provide analysis that they previously completed. So when you previously put this particular valuation advisor on your list, what did you do? What was the process? What is the analysis? That analysis has to be completed within the last 15 months if you're going to rely on it, and so on and so forth. And so I would say for our internal trustees, what this really gives to us is just a guide to make sure that both the external and the internal trustees are not just seeking recommendations blindly from perhaps other professionals in the community, that you are documenting, that you have talked to the particular valuation advisor, that you have asked them the questions that need to be asked, because it is in selecting that valuation firm, you are, as a trustee, making a fiduciary decision. So you want to have a good record of going through that process and making sure you are aware of who the valuation firm is. And as we can all look at, as a bad example, a very recent case that came down, the Brewster decision, is certainly evidence of some really bad facts. But the last thing you want is for it to come out later that your valuation advisor was a felon. It may not have any impact on your particular value, but it's certainly not a good fact. So making sure that you've documented the process of who you've selected, that does not mean that an internal trustee necessarily has to look at more than one valuation firm. If that particular valuation firm is a well-known ESOP evaluator, and you've documented, their background and checked their references, I'm not going to say that you have to do that for multiple valuation firms. I just want to make sure that our internal trustees are not relying on the information provided from other parties. So in addition to making sure that they're qualified, we are now really focused on something that has been talked about for a while, and that is the independence of the valuation firm. So it has been, as I said, talked about for a while. What does that mean? Can a valuation firm assist the company or a committee of the company in establishing an initial value and then utilize that sort of test value for going forward with an ESOP transaction, and then having a valuation firm work on behalf of the trustee, sort of moving from a committee that was formed for purposes of putting in place an ESOP to the actual ESOP trustee. So clearly what the Department of Labor does not like is that sort of a structure. I think there will probably be some exceptions to that rule where you do have a very legitimate committee at a company that's looking to do an ESOP and trying to get a sense for value, and can still utilize that same valuation firm on the trustee team. But I think those are going to be rare occasions. What we need to do is make sure that the valuation firm is absolutely independent from the company, from the company's advisors, from the sellers, that there's no relationship really between the valuation firm and the company that's being valued. We have actually now included in our transactions a financial advisor certificate so that the financial advisor can certify that they are not related to any of the parties involved in the transaction, and has provided services fully on behalf of the trustee. So this is going to be an important one to make sure if you're involved in as a trustee in the purchase or sale of an ESOP stock, that valuation firm that's assisting on coming up with stock value is really and truly independent. So now that we've gone through the process of hiring the valuation firm, DOL is now focused on the process itself. Unfortunately, the Department of Labor has really had on its desk, as we have seen, a number of really atrocious cases, cases where valuation firms truly were not qualified to provide the services in an ESOP transaction. Unfortunately, bad facts. So focusing on those bad facts, Department of Labor put together what they believe the valuation advisor has to document in their process. And I've seen valuation firms, including this, which is great, in the documentation and in the actual report for transaction purposes. There's a lot more focus on who is responsible for providing the projections. There is typically some explanation of what the potential conflicts of those people might be, and why or why not the projections are solid, or were revised in some way because of that conflict. The report has explained the reasonableness of the projections in light of its history. So these are things that it's not that they were not focused on in the past, but they were typically probably discussed by the trustees and the valuation firm and many times legal counsel, but they weren't necessarily documented. So they didn't come out so that when the Department of Labor came in and looked at the record, these particular items were not reflected well in the record. There are more discussions that were had during the process of going through a transaction. And so what Department of Labor is saying is, for your own good, let's include this in the documentation. Continuing on the valuation process, again, these are items that were always considered in the past. It's just that now we want to document them further. So if there are any metrics that are disregarded in the process, a written calculation of the metrics and the basis for concluding that it should be disregarded. So instead of just the valuation firm, going through that and disregarding it, we now have to say in the valuation report that was considered and disregarded. If the company is projected to meet or exceed its historical performance, written documentation of all assumptions suggesting such an explanation of why they are reasonable. Again, pretty realistic, reasonable request here. Any adjustments made to the projections, rationales for the adjustments to the company's historical expected financial metrics, really a focus on what most valuations are based on, and using the DCF method, looking at the projections and whether to accept the projections that's provided by management typically, or whether those projections have to be modified in some way. And DOL really honing in on, especially in the light of some companies that unfortunately took a dip in the recession, and those companies sold just immediately before the recession, and obviously the projections look rosy. No trustee in the world could have projected that those projections were going to be off. But to the extent, I guess, that there was more in the record, more discussion about those projections, that would have been great. Not to say that those complaints still would not have been filed by the Department of Labor, but I think it would have been easier for the Department of Labor to understand where the trustees were coming from if they had better documentation. Just putting it out there, not sure if it's true or not, but hey, that's what they're suggesting here. If greater weight is assigned to some valuation methods than other, explanation as to the weight. So I think we have all seen those valuation reports. Again, bad facts, but valuation reports where they're changing the weighting of the various methodologies that are included in the valuation report. And they don't really explain why, and then it may change in another year. They don't say why they prescribe certain weightings to the various methods that are used in the valuation report. I would say this doesn't happen very often, that those who are involved in the ESOP community generally have been historically doing this. So again, this is one where most of the valuation firms that work in the ESOP space are just going to check the box and say, yeah, we already do that, while others who may not particularly work in the industry but do one-off valuations, they're really going to have to focus on that. And it's certainly a consideration for the trustees, both external and internal, to make sure that that information is included in the report, to make sure that something that simple can be really checked off the list. Consider how the document provisions regarding stock distributions may affect the repurchase obligation. So this is an interesting one because we don't typically get the benefit of reducing value for any sort of document provisions, but I think the Department of Labor is looking for us to at least take notice of what's happening in the operations post-sale of stock to the ESOP, what's happening in the operations of the plan, and who's going to be eligible for distributions. Are we going to have some significant repurchase needs? I don't necessarily think this is going to impact value, but I think it's the Department of Labor's way of pointing to the trustees and saying, hey, you should be involved in making sure that we don't have a situation where an ESOP transaction is set up where year 2, 3, 4 down the road, because of the terms of the document, we have a company that's struggling to make its way. So I think this is more of note it for the record, and it's not really going to impact value. And I've seen some of the external trustees really focusing on this, and I think that's good, at least bringing it to the attention of the company when we have a situation where there might be some stress put on the company based on plan document provisions. So that the idea being that the trustees are, especially the institutional trustees who this particular process requirement is focused at, they have the experience in the industry and should be at least raising the flag if something looks like it's going to be problematic in the future. So next little point is analyzing whether the ESOP sponsor will be able to service the debt from the transaction. Is the transaction financially and relatively fair? So we'll start with the first one. Can the company service the debt? Obviously, we don't want to do transactions where we're setting up a debt structure in which a company is just not going to be able to manage its debt load. I don't think we find that often amongst the advisors in the ESOP space anyways, but again, that is facts out there for the Department of Labor, so they want us to focus on this. This is another one of those where historically it has been done. Trustees certainly have focused on making sure that they don't put a debt load on the company that will not be serviced appropriately. Is the transaction financially and relatively fair to the ESOP? Just want to note this one's been talked about quite a bit recently. This does not mean that the Department of Labor is requiring a fairness opinion in every transaction. That is an opinion that I think has become more common and routine in transactions in which the valuation firm provides its opinion that the terms of the transaction are fair from a financial viewpoint to the ESOP, and certainly relative to the other parties that might be involved in the transaction. There are times at which we have found certainly a fairness opinion is not necessary, and so I think it's important to state here that this particular provision does not mean that there is a fairness opinion requirement by the Department of Labor. It just means that the trustee really has to come to a conclusion and check that box, and should be doing this anyways. Is the financing market-based, commercially reasonable, and financial impact of the transaction on the sponsor? So again, all very normal points that I think we've historically had trustees focusing on anyways. One that's a little different is the financial statements. So you may have heard this. Some of the trustees on the phone certainly have already dealt with it. The Department of Labor believes that a company that's involved in ESOP and buying or selling stock here should have audited, unqualified, CPA-prepared financial statements for the past 5 years, unless unavailable, in which case as far back as possible. So the question here, and I think some trustees have decided, how they want to proceed on this, but in the absence of audited, unqualified financials, it basically puts a trustee in a position where they have to document why they believe it is prudent to rely on unaudited or qualified financial statements. So the key here is, while it would be great to have 5 years of audited financial statements in every company that is entering into an ESOP transaction, that's just not the case. So the trustees involved in those transactions really just have to have some good documentation, I think, of either perhaps modifying or adding some risk to the projections based on unaudited financial statements, or tying out those financial statements to other operational aspects of that company, and really determining why it makes sense to rely on those unaudited financial statements, and again, documenting that position. So this is not a situation where we have to have audited financial statements in order to complete any ESOP to purchase of stock. Certainly is a best practice if we can get it, but I don't want this to be read. Certainly it's not, from our perspective at SFE&G, a requirement on companies. Once we get through that part of the process requirement, we're now looking at the fiduciary review process. So this is with respect to the trustees. We've talked about what's going to be good evidence from the Department of Labor's perspective of the rate financial advisor was selected, a qualified financial advisor valuation firm, what documentation of that engagement process, and then what details should be included in their report. So then we turn from the valuation firm to, and I should point out there were 9 different points in the requirements for that process, or for the report. So now we turn to the fiduciary review process. From the trustee's perspective, we're taking reasonable steps to determine the prudence of relying on the ESOP sponsor's financial statements. We just talked about that. Critically assessing the reasonableness of any projections. Again, honing in again on, from the Department of Labor's perspective, the projections that we're providing, and really making sure that we're not, as trustees, the trustees are not just accepting what is provided to them, but they understand where they came from, who developed them, and really asking a lot of questions about those projections. And then the bottom bullet point, and I should let you guys know that the highlighting in green here indicates document, document, document. So document the basis for concluding that the information supplied was current, complete, and accurate. And this goes back to the initial point that Department of Labor included in the beginning of the settlement agreement. The trustee is responsible for making sure that the valuation advisor has the current, complete, and accurate information on which to support its analysis. And so here we have the DOL saying not only should the valuation report be saying that, but the trustee should be documenting that that is something they've taken care of. We need documentation to specifically address marketability discount, minority interest and control premiums, and future company projections and reasonableness. So again, these are aspects of a valuation analysis that have historically been really documented well in most reports, but we have those bad fact areas. So marketability discounts can vary from company to company. We know what the general marketability discounts are in the ESOP area, but some reports that are sort of bad fact basis really don't give any support to why the discount is 5%, 10%, whatever it is. We have minority interest in control and controlled premiums, I should say. Why does a valuation firm select a minority interest discount of X or a controlled premium of Y? So again, bad facts. Some valuation reports including nothing more than just the discount or the premium and not really indicating why they selected that particular premium or discount. So again, check the box, but most of our ESOP valuation firms are doing these things already. Future company projections and reasonableness. This all just goes into the document space. This is, I think, Department of Labor, sort of scratching their head and going, when we started these complaints against Great Bank, why did they have this stuff already in their records? It just seems like it should be there. And so we probably have a handful of valuation firms who weren't doing a very thorough job, and so that's where these things come up. Analysis of the company's strengths and weaknesses. I believe there are, you can hear 16 different points that are listed on us for the valuation analysis. Analysis of the company's strengths and weaknesses, specific discount rates, the adjustments to historical financial statements. All of these things should be already part of a typical valuation report that's prepared in conjunction with a purchase or sale of stock by an ESOP. Consistency of the narrative in the valuation report, it really just goes to is somebody reading it and making sure that the terms are consistent, that the description is consistent. Reliability and timeliness of the historical financial data considered. DOL has stumbled across those reports where the historical financial data was probably outdated. Unfortunately, I've seen a few of those myself. So that would just be indicative of trustees not really paying attention, that's not reading that report. Comparability of companies chosen as part of an analysis. Again, all of these are coming out of the bad facts category. And the lesson learned is if you are a trustee, make sure you're reading that report and make sure that you can tick off these 16 items. I would assume that most of those on the phone can probably, you're paying attention. Obviously, you would not be on a webcast. So you're probably paying as much attention to your valuation firm and their report. So you probably can go right through your report and tick all these off. But if you can't, these are items that you want to go through and make sure are included in the report. Material assumptions underlying the valuation report, these should be documented, not just assumptions, but they should be written somewhere. Where the valuation report made choices between averages, medians, and the reason for those choices, you're basically creating a record to say why the process you went through in getting to the value as a trustee is supportable. And if the end result, 2 years from now, 2020 hindsight says it's wrong, at least you have the process and documentation of that process. Treatment of corporate debt, whether the methodologies were standard and accepted, and on and on. ESOP's responsibility to service the debt liability taken in conjunction with the transaction, which was one that was touched on previously. The reasonable foreseeable risks of the proposed transaction. These are all details that if you were buying a company, you would want to see, as an individual included in that report. And then, of course, any other material considerations. So moving on from the 16 points that we want to make sure are covered in any transaction valuation, documentation of the trustee's work with respect to the following were also included as points that, of course, Great Bank will be required to maintain. And this is an area where I would say, not particularly, I don't think these points, but there are some details in this section of the process requirements where I think trustees have to make a decision of how far they want to go. So reading and understanding the report, of course, every trustee should be doing that. Identifying and questioning the report's underlying assumptions. We're going to document that as you go through the report with the valuation firm. Again, the importance here is documenting. I think all trustees are doing these things, or most trustees, they're just not documenting it. So when the Department of Labor comes back around and asks those questions, they don't have the documentation that they did X, Y, and Z. Reasonably inquiring as to whether the report is consistent with the information Great Bank has. And so obviously the Great Bank is replaced by the trustee. Analyzing whether the report's conclusions are consistent with the data analyses. And then this one, documentation of the ideas of the personnel who are involved primarily for the proposed transaction, and who disagreed and why, and whether they expressed opinions. So this one is really focused on those institutional trustees that work, I think, by committee. This could be, applied to a committee of internal trustees, but certainly because the Great Bank Trust Company was involved in this one, there was more attention on the how that committee was composed and what the Department of Labor is looking for. Typically, we do have the identification of the people who are involved primarily in the proposed transaction. There is a lead person in institutional trustees, and that is documented. Typically, the minutes of meetings will identify who disagreed with an aspect of the transaction and what the outcome was. I think we have to walk that line, however, as to really handing, a documented support for DOL to bring a complaint versus a record that indicates that there was a healthy discussion around an issue and there was, agreement and disagreement, and then ultimately everybody agreed to proceed, for instance. There is that line, and so that I think is one where folks have to sort of decide how much they want to provide in the way of documentation. Preservation of documents, this is going to the idea of litigation, of course. I've certainly been involved myself in a couple of investigations by DOL where, unfortunately, when seeking documents, we had to say, we don't have X, Y, and Z because either a hard drive crashed or a document destruction policy was implemented, or you name it. And so, we lack the documentation to prove the process. And so DOL has now required of Great Bank Trust Company that they create and preserve the documents for at least 6 years, and all of the names and numbers and contact information for those on the committee. There must have been some issue with being able to track down somebody who was on their committee in one of those cases. And then the votes yes or no of each of the members. In my experience, I don't think I've seen a committee yet where the vote is typically unanimous by the time we get to the vote. There might be some healthy discussion throughout the meeting, but generally, the idea is for everyone to reach consensus that the transaction is a good one. So again, that line where you want to make sure that you're documenting what needs to be documented. Document retention, retaining notes and records created in connection with consideration of the proposed transaction. Certainly, there is a limitation to what can be kept and what shouldn't be kept. Drafts, I think there is a recommendation at this point, and some of the trustees are doing this, where there is a negotiation that happens between the trustee and a seller in the ESOP purchase of stock. And I think historically, while there's been email communication and perhaps some phone calls in there hasn't on occasion been a good documentation, a good record created to solidify that negotiation took place. I think some advisors have been a little more focused on that than others, but I know that some of the trustees are now requiring a memo to really make a solid record of what happened in the negotiation, so that we don't just go through the process, which is a good one, going back and forth a couple of times. It was a negotiation on the price for the sale or purchase of stock. But when we look back at it in 3 years, what happened? And either people have left, you don't know, you can't track them down. But now we have a document that reflects what the process was, and so that is certainly a good addition into the transaction itself. All written communications had with service providers, the ESOP sponsor, and any ESOP counterparties, and any advisors retained by the ESOP. Again, there is a line that everybody has to sort of figure out what amount of information is the right amount of information to keep for 6 years. And this, of course, is something that Great Bank has agreed to, this 1 through 5 details, but it does not necessarily mean that every other trustee is going to keep that amount of information and documentation to support the previous process. So that's something that has to be considered. So moving on to another aspect, fair market value. And this is one that probably will not impact many transactions, but Great Bank agreed that the trustee will not cause an ESOP to buy employer securities for more than a fair market value. Now, I understand that this was sort of a give from Great Bank's perspective, that they argued. It seems counterintuitive here. Of course, the trustee is not going to cause the ESOP to pay more than fair market value for stock. That's the whole point of the valuation process. Or bullet point 2, the trustee will not cause the ESOP to engage in a leveraged stock purchase. The issue here is that there is some particular valuation methodology that will allow for pricing or value of seller debt or debt instruments to be priced different because of its terms. And I'm not going to get into the details because I am not a valuation expert, but let's just say that by pricing the seller debt at less than face value, it could reflect or conclude that the ESOP is thus overpaying for the stock at the end of the day. And so DOL saw this in a couple of situations, and so they're focused on that. But this is a rare occasion. This does not happen in every transaction or the majority of transactions for that matter. But it's something obviously that was seen with Great Bank. And I think we're getting close to the end here. The consideration of a clawback. I think that this is fairly new to ESOP transactions. It's not new in the typical M&A world, mergers and acquisitions, but it seems appropriate in some transactions and others not so much. But the Department of Labor wants trustees to consider whether it's appropriate to ask for a clawback arrangement. And this is really a description of a trustee agreeing to pay a price of, say, $20 million, but including in that price, there's a clawback that says if you don't hit certain targets, whether that's EBITDA, revenue, whatever it is, then you're going to return some of those funds. It's not going to be $20 million. It's going to be a $15 million purchase price. And there are some companies where they haven't historically hit the targets that they're projecting, or there's some risk in some areas of their business. And so it's appropriate to ask that company or that seller to provide a clawback, that the value is not going to be appropriate unless certain marks, certain EBITDA targets are hit. But the DOL, understands that that's not going to be the case in every transaction. So it doesn't mean that a trustee has to require, I don't think it even means that the trustee has to request in every transaction a clawback. But it's just one more detail of an ESOP transaction that can be considered by the trustee, and certainly having a record that it was considered will bode well for the trustee. And then again, keeping written documentation of the consideration, because nobody is going to remember that the trustees thought about a clawback for a review of the transaction. And then I believe this is the last slide. Remember that I think DOL certainly wants us to remember that ERISA Section 404 still applies, that these fiduciary process guidelines are not the end-all be-all. Just because you can check the box on every single one of those does not mean that you have met your fiduciary requirements, and there will be no claim for a breach. A fiduciary still has to discharge their duties with care, skill, prudence, and diligence under the circumstances and prevailing that a prudent man acting in a like capacity and familiar with such matters would use in conduct of enterprise of a like character and with like aims. So what may be right in one transaction using those procedures may not be conclusive in another. So we have to remember that the standard of prudence for a fiduciary is a very high standard and may require us to incorporate, and certainly I know we do additional processes depending on the transaction involved, above and beyond what the fiduciary process guidelines require. So Jeff, I don't know, can you unmute the line for a few questions? We do have a few minutes. I'm using a new program here, so I'm not sure if that's possible or not. Or if anybody has a question they want to submit through Join Me, I believe there is a way that you can type in a question, because I've seen little pop-ups, the chat feature. I do want to know, one of the purchases that happens more often now, that's not a full-blown transaction, it's not an ESOP purchasing stock from a selling shareholder, but more in the administration of ESOPs is what we call a releveraging. And that is as part of just general administration, and in order to fund distributions, companies will, the ESOP will basically sell stock to the company through a redemption. And there are a couple of ways to do that, but we typically structure it in such a way that it's a redemption, and then the company will sell that stock back to the ESOP. Most of the time, the purpose for that is it's a mature ESOP. We need to get some additional shares back into circulation, and so we call that a re-leverage. It's a redemption followed by an ESOP purchase directly from the company. And by definition, that is a purchase and sale of stock in both of those scenarios. The redemption directly from the ESOP is certainly a prohibited transaction that requires a simultaneous valuation. And then the resale of that stock to the ESOP, again, is potentially a prohibited transaction. So that definitely falls within the realm of what the fiduciary guidelines, fiduciary process guidelines are talking about. And so the real question is, do we have to go through in a re-leveraging situation where it's really just for administrative purposes, the full-blown transaction? And our position is that it does not require a full-blown transaction. But what I would caution specifically our internal trustees on is I think it's been seen as sort of routine and ordinary to do, a re-leverage and just pick up the valuation from, maybe you had the same valuation from the last 10 years, and now you're doing a re-leverage and using that valuation for that purpose. I think you want to be a little more focused, we'll say, on the valuation process, and maybe take the guidelines and go through and check the boxes to make sure that valuation report does stand up and does have all of the information and documented details, because it is a little bit different than your typical administration. Okay, so I'm getting comments and I have to figure out how to get them. I got a question. Do you think that the trustee should expect the valuation firm to document the issues regarding the projections and reliance on non-qualified audited financial statements? I do think that evaluation firms have increased the amount of disclosure and explanation that's included in their reports. Most of the valuation firms that work primarily with ESOP transactions, I have definitely seen that coming through, where they're talking about who's providing the projections, are they conflicted, why the conflict is good or bad, or how they've adjusted the projections based on the fact that we have conflicted party, maybe the CFO, that's providing the projections and also engaged as a seller. And the non-qualified audited financial statements is definitely a conversation that trustees are having with the valuation firm. Tying out the tax returns for that company to those unaudited statements is a good first step. But to the extent that the valuation firm is really that financial expert, we'll call them, they are giving insight. I don't think the valuation firms want to, cross the line and be giving opinions with respect to the financial statements, but they can give some feedback. So they're not going to tell you that your unaudited financial statements are good or bad or anything like that, because that puts them, into the position of becoming the auditor, which doesn't make sense. But they can certainly give some feedback on, as they've done their analysis and looked through the financial information, if something seems suspect. Hopefully that answers your question. I see some of our viewers have figured out the chat feature. Any others? Well, we will certainly post the PowerPoint on the website, so the same locations where you go to sign up for the PowerPoint presentation, I believe, and will, I believe, circulate a evaluation so that you can give us some feedback on this particular webcast. And I would also offer up a copy of the fiduciary process requirements, so that you can have access to those readily as well. I think we can post those on the website as well. So I hope that everybody found some portion of this useful. I think the big takeaway is document, document, document. And just making sure that your evaluation reports, if there's a conclusion and no explanation, then you need to ask the valuation firm to include an explanation, basically. And I hope you enjoyed it. So if there are any questions, please feel free to call or email me. I'm happy to share my views here. And I hope you all have a great day.